As we are aware that Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023, and Bharatiya Sakshya Adhiniyam 2023 will replace the British era colonial laws, namely the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act, respectively. The central government has appointed the first day of July 2024 as the date on which the provisions of these new criminal laws will come into force. Regarding the gazette notifications are concerned, it also published in this regard in 24th of February 2024. UGC has requested all universities and colleges to organize such kind of the seminars or self-paced programs to sensitize the students and the faculties about the overview of the changes introduced in the new criminal laws. So this video is prepared for the purpose of as a sensitization program on the new criminal laws, overview of the new criminal laws. So why these new criminal laws are required, why it came into existence, there is a serious concerns about the existing criminal justice system. For example, complex nature of the legal proceedings, large number of pendency of cases in the court, conviction rate is very low. As far as the amount of fine is concerned, ambiguities are there in the measurement of a fine. Large number of under-trial prisoners or population. Lack of the use of a technology in the legal system. More delay in investigation. Delay in the case progression. Investigation procedure is very complex one. Apart from there's a insufficient use of a forensic evidence. So these are the some concerns regarding existing criminal justice. So how these new criminal laws came into existence? What the evolution of these new criminal laws are there? As far as the time span is concerned, these are the chronological events. So total 4 year, 3 month, 17 days are required. These new criminal laws came into existence. The actual process start from 7th September 2019 and culminated in 25th December 2023. Various suggestions are received from the 18 states, Union Territory, Supreme Court of the India, 16 High Courts, National Judicial Academia, State Judicial Academicians, National Law Universities, Member of Parliaments. So all suggestions are received from September 2019 to December 2021. And then the report is submitted in February 2022. So 2nd March 2020, committee is constituted under the chairmanship of Vice Chancellor, National Law University, Delhi, and the report is submitted in February 2022. Then the bill is introduced under the name of Bharatiya Nagarik Suraksha Sanhita 2023 rather than CRPC, replacing the CRPC. Bharatiya Sakshya Adhiniyam 2023, replacing the Indian Evidence Act. Bharatiya Nyaya Sanhita 2023, replacing the Indian Penal Code. These bills were actually introduced in Lok Sabha on 11th August 2023. And again it's sent to the Parliamentary Standing Committee. And then Parliamentary Standing Committee again submit the report on 10th November 2023. And after submission of the report in 10th November 2023, bill is reintroduced and on 25th December 2023, these three bills received presidential assent. President signed these three bills and it becomes an act of parliament. It is notified in the gazette as well. And they fixed the new date of enforcement on 1st July 2024. So July 1st, 2024, where actual new criminal laws will be implemented. It starts operative, it becomes effective. As far as the comparison is concerned about the three new criminal laws, what changes are there? In Bharatiya Nyaya Sanhita 2023, which is earlierly known as the Indian Penal Code 1860, 190 major and minor changes have been introduced. 20 new offenses have been added. 19 provisions have been deleted. In 19, 8 are offenses. In 41 offenses, punishment of imprisonment is increased. It is to be enhanced. In 83 offenses, punishment of fine, which is previously very less, it is increased. It is enhanced. In 23 offenses, mandatory minimum punishment has been introduced. In 6 offenses, community service is a form of punishment for PT offenses has been introduced. In Bharatiya Nagarik Suraksha Sanhita 2023, 360 major and minor changes have been introduced and 177 provisions have been modified. So large number of changes have been introduced in the BNSS, which is earlierly CRPC, Criminal Procedure Code. 9 sections have been added. 30 new subsections, subclauses have been added. 49 new provisions are also added. And in 39 places of the Bharatiya Nagarik Suraksha Sanhita, audio, video, electronic means have been introduced just for the purpose of using of a technology in investigation in the courtroom. In 45 places, fixed timelines have been fixed for an investigation. Total 15 provisions have been deleted. In Bharatiya Sakshya Adhiniyam 2023, earlier it's known as a Indian Evidence Act, Law of Evidence 1872. 45 major and minor changes have been introduced. Total 24 provisions have been modified in BSA 2023. 5 new explanations have been added. 11 sections and subsections have been deleted. Total 5 explanations also been deleted. But one more important schedule is attached. It is annexed in the Bharatiya Sakshya Adhiniyam, which deals with the format of certificates. When any electronic record is required to be submitted in the courtroom, two format of certificates are attached. One is submitted by the party, other is submitted by the expert. So the format of certificate is mentioned, it is attached as an schedule. These are the nomenclatures about the Bharatiya Nyaya Sanhita, which replacing IPC, Bharatiya Nagarik Suraksha Sanhita replacing CRPC, Bharatiya Sakshya Adhiniyam replacing Indian Evidence Act. The purpose or the objective behind these new criminal laws are to make the criminal justice system more accessible. Accessible means to all, accountable, credible, and justice driven. Another thing is transparency. So system want to become more transparent, modern, and technologically adept. They try to address the contemporary challenges. They try to adapt the contemporary challenges. One more important feature about the introduction of the new criminal laws are one can lodge an EFIR. One can lodge an EFIR means electronically FIR. Previously, the traditional presence are required to file the FIR. But now EFR is one of the most notable feature which is introduced by the new criminal laws. Zero FIR also one of the more notable feature. Zero FIR at any police station, regardless of their jurisdiction boundary. Even delivery or getting a copy electronically also. Get informed about the progress of investigation within the timeline of 90 days. Supplying of the case related documents through email with even specified time frame. Even in accused persons, victims are there, witnesses are there, they can appear through audio video conferencing. So this audio video communication is a one of the notable feature introduced by the new criminal laws. So any accused victim, even witness, if they want to appear for the purpose of examination and they want to depose the evidence through audio video mode, they can do so under the new criminal laws. Most important approach about these new criminal laws are there as far as the victim centric approach or witness centric approach. Just we mentioned about the traditional requirement of physical visiting police station and filing an FIR has been completely replaced with the filing of FIR through electronic communication, EFIR. as far as how to file EFIR and how to take the uh, e-filing of FIR by the police machinery. Recently, the Ministry of the Home Affairs also introduced and published a SOPs regarding the zero FIR and EFIR are concerned. It's a very important approach as a zero FIR regardless of boundary. So previous limit is there. If you want to register an FIR, only at the jurisdiction bound police station has been there. It is not eliminated. It permits the victim to file an FIR at any police station in the country. There is no any jurisdiction boundary. So this incorporation of a zero FIR and EFIR in India's new criminal laws, it is a it signifies a transformative steps towards the modernizing the country justice system. Because zero FIR allows victim to file FIR at any police station irrespective of jurisdiction. It ensures the barrier-free access to legal recourse. It's very beneficial for the victims, even in case of the urgent and very threatening situations. It also facilitates the immediate police action, even the timely preservation of evidence. Complementing this, introduction of the EFIR, it also enables the online filing of FIR. It broadens the accessibility, it convenience for the public. So, by leveraging the digital platform, these EFIR really minimize the need for the physical presence at police stations. It reduces the delay also, even the administrative burdens as well. So naturally, these reforms of zero FIR and EFIR, it reflect the commitment to victim-centric justice, and they tries to align with the global based practices. Even in case of certain offenses against women are concerned, it is authorized that the FIR be registered by a woman police officer. And even moreover, if the victim is temporarily and permanently mentally and physically disabled, FIR shall be recorded in his or her residence. Such kind of the victim-centric approach are there. If suppose FIR is not registered, victim has a remedy. He directly approach to SP, Superintendent of Police. SP may investigate the offense himself or he may direct the investigation by a subordinate officer. Especially in case of the offenses punishable with imprisonment between 3 to 7 years, and SHO, after seeking the permission from the DSP, may conduct the preliminary inquiry within 14 days. Now, as far as the preliminary inquiry are concerned, timeline is clearly fixed about the 14 days is the period about conduction of the preliminary inquiry. So, to provide the guidelines for conducting the preliminary inquiries as per section 173 clause 3 of the Bharatiya Nagarik Suraksha Sanhita 2023, Ministry of the Home Affairs recently also published a SOPs, Standard Operating Procedures for Preliminary Inquiry under the BNSS 2023. So the SOP which are provided by the Ministry of Home Affairs, their object is to ensure all inquiries are carried out effectively, lawfully, which tries to uphold the rights of the parties. So an initial investigation just to ascertain whether there exists a prima facie case for the offences which in between 3 to 7 years, and then proceed with the full investigation. And that's why these kind of the preliminary inquiry is there. The conduction is mentioned about the timeline is about 14 days. So it's an evolution. The provision of the preliminary inquiry, which should be conducted within 14 days under the Bharatiya Nagarik Suraksha Sanhita 2023, it's an evolution from the guidelines which are actually set forth in the Lalita Kumari judgment. Because the Lalita Kumari judgment mandated that the FIR must be registered. And if the information discloses a cognizable offense and allowed the preliminary inquiries only to determine if a cognizable offense is revealed, then the BNSS 2023 really expand the scope. So under this Bharatiya Nagarik Suraksha Sanhita, preliminary inquiries are conducted to ascertain whether there is a prima facie case for the offenses between punishable of 3 years more or less than 7 years. So this judgment is very important. The unlike the Lalita Kumari guidelines, which specify categories also like in case of matrimonial disputes, commercial offenses, even in case of medical negligence, BNSS applies broadly to all relevant offenses within the defined punishment range. So this is a very important case. And as far as the apex court in the Lalita Kumari judgment also provided direction that in case where preliminary inquiry ends in closing the complaint, a copy of the entry of such closure must be supplied to the first informant forthwith, not later than 1 week. It must disclose the reasons also in brief for closing the complaint and not proceeding the further. So these are in line with the judgment. Even if the offence suppose remain unregistered, despite approaching the SP, the victim is empowered to seek the magistrate intervention who may direct the investigation after hearing the submission of the police officer. Apart from some notable features also there as far as the new criminal laws are concerned about the forensic investigation. So in case of the forensic investigation is mandated compulsorily for the offences which are punishable with more than 7 years for the purpose of thorough evidence collection and analysis. So victims' right is further fortified by ensuring a thorough investigation which is supported by forensic expertise. As far as the copies are concerned, to get a free copy of their FIR by the police without any delay. To strengthen this intention, now police are mandated to inform the victims also even the progress of his investigation within 90 days of the investigation. So timeline is again fixed. Within 90 days of the investigation, progress must be given to the victim by the police. As far as the vulnerable sections are concerned, those who belong to the rape victims, some steps have been taken by the new criminal laws to provide a more conducive or more beneficial environment. The statement of a rape victim shall be recorded electronically also by a woman police officer. And it must be recorded at a convenient place for the victim's place, with the guardians to be present, relatives to be present, and moreover, the medical examination of such a victim shall be conducted with her consent. With her consent. And moreover, the report to be submitted, to be forwarded by the medical practitioners to the investigating officer, it should be within 7 days. So 7 days is the timeline where the rape victim's medical examination report to be submitted by the medical practitioners to the IO. So timeline is also fixed by the new criminal laws. As far as just we mentioned about the supply of documentation, it apart from supply of documentation to the victim, it also mentions a supply is possible to electronic way also. So technology is leveraged to enable the electronic deposition of the evidence also by the victims. Moreover, the rights of the victims also protected by free medical treatment, even victims' compensations also. It clearly mention all public and private hospital, they duty bound to provide free medical treatment in case of the heinous kind of the offenses which are against the women as well as the children, which includes the acid attack cases. Apart from witness protection scheme has been launched as per this new laws. New laws provided the witness protection schemes because number of times witness not want to come in the courtroom because they are harassed, they are intimidated. So it requires some protection. Such scheme is launched by the new criminal laws. And first time the victim is entitled to get a free copy of the judgment just merely on application to the court. Until now, what happened? There is no such provision, clear cut provision of providing the judgment to the victim, and victim had to wait for prolonged periods when the judgment is uploaded online and then he have access to get it. Apart from those citizens who are above 60 years, previously the age is about 65 years, but now it's a 60 years. So those citizens who have 60 years above, women and people, they are if they are physically disabled, so these peoples are freed from the present themselves in the police station for investigation purpose. And the persons who are above the age of 60 years and they are supposed infirm, they are even protected from the arrest for an offense which are punishable with less than 3 years. Next approach, very important approach taken by these new criminal laws, increasing the credibility of the evidences, even the accountability. police accountability, and the court using the technology. As far as technology is concerned, the BNS, Bharatiya Nyaya Sanhita, earlier Indian Penal Code, recognizes certain kind of the offenses which are committed using electronic means. Now, apart from the IT Act or cyber crimes, mostly they also come under the BNS also. Those offenses which are committed comes under the committed under using a electronic meanings, electronic devices. Such some of the offenses also covered under the BNS Act. Even in the BNSS, Bharatiya Nagarik Suraksha Sanhita, it leverages technology for registration of a EFIR, electronic servicing of a summons, e-summons can be issued, supply of the case-related documents to all parties, even search and seizure proceedings using of a audio video mode are concerned, court proceedings are concerned, forensic experts in evidence collection. So all these kind of the provisions emphasized the courts are using a technology. Now, as far as the expert certifications also required to authenticate the electronic records. Now, the court are flooded with more kind of the electronic evidences, digital evidences. Now, the parties are submitted number of times the electronic record as an evidence. Apart from physical evidences, electronic records are submitted in the courts number of times. So, for that, while submitting the electronic records in the courtroom, they have to submit certificates, expert certificates. In previous law, no such kind of formats are attached, mentioned. But under the new law, Bharatiya Sakshya Adhiniyam, expert certification is compulsory there now to authenticate the electronic records and their certificates also provided. To adapt the digital era, definition of document and the evidence, it will be expanded, which includes now digital era. Various forms of the stored electronic data like ATM files, cloud storage files, broadcast videos, emails, location data, explicitly expressly outlined as an admissible evidence in the new criminal laws. Another important notable changes is about the transparent and accountable justice system. So every police station, even the district, they now have a designated police officer, not below the rank of a ASI, and they displayed prominently displayed the information of the arrested individuals in every police station. And those person, if that person is detained without warrant by the police, that persons can be immediately within 24 hours produced before the magistrate, any magistrate, without any jurisdiction, regardless of the magistrate jurisdiction. Just like in zero FIR, without any jurisdiction of the police station, you can file FIR any police station. Similarly, if any person is detained without warrant, so he can be produced within 24 hours before any kind of magistrate, regardless of the magistrate judicial boundary. Apart from the timeline for the completion of investigation, the word further investigation, it should be completed within 90 days, within 3 months, we can say, after filing of the charge sheet. So timeline is fixed. Here, police accountability is increased. All search and seizure proceedings are conducted by the audio video recorded. So technology is leverage used by the court proceedings. As far as the how the search and seizure proceedings to be conducted by the audio video means, recently the Ministry of the Home Affairs also published a SOPs, standard operating procedures for all the police officials, all the IOs regarding the audio video recordings, even the search and seizures proceedings to be conducted by the police. First time in absentia trial has been established to address the problem of absconding criminals or fugitive criminals. Earlier, there was no provision of a trial in absentia, but the courts could go not that time. Courts want to only record the evidence in absence of the accused, and that may cause delay in the cases, pendency of the cases, and it may reduce the confidence or trust, public trust in the justice mechanism. Plea bargaining has been time bound. Concept of plea bargaining, previously it's there, but no time bound provisions are there. But now in the new criminal laws, a period of a 30 days is fixed from the date of framing of charges for the purpose of filing an application for plea bargaining. Apart from the timeline, those who are a first time offender, first instance offender, punishments are given very less punitive approach are there. Mostly community service as a form of punishment is adopted, not the rigorous punishment. Apart from new provisions are inserted as a mutually satisfactory disposition. A period of 60 days has been prescribed for completing this kind of process, where the victim, prosecution, accused person, IO, they come together, they work out in a very satisfactory disposition of the case, known as a mutually satisfactory disposition. Timeline is fixed for 60 days. First time, clear distinction is made between the adjudication of PT offenses and the most serious offenses. Apart from summary trial has been mandated for the small offenses like the theft, receiving or retaining stolen property or insult, and magistrate is now empowered to try the summary trial. Summary offenses which are punishable, which are less than 3 years instead of a two. Previously it's a 2 years, but now it's a 3 years. And community kind of service has been introduced as a punitive kind of measure for PT kind of the offenses. Next approach which centralized by the new criminal laws are restorative peace and security of the nation. So as an introduction of the rights of the nation, if you read the IPC, one finds that there's no clear mention of the word sovereignty, unity, integrity, and security of the India. But the IPC only mentioned the sovereignty and the integrity in section 153B. Absence of such provision, it can lose the uh, colonial colonial roots are there, and they try the colonial rules punish the subjects, because Britishers when came into India they come as a traders, but now later they becomes a rulers of the nation, and they drafted such kind of provisions which they try to punish the subjects in the colonial provision way. So the Bharatiya Nyaya Sanhita recently not only embraces the Indian nomenclature, but they also bestow the paramount supremacy to the sovereignty, unity, integrity, and security of the India. They try to signify the sovereign border of the nation. Three new offenses have been introduced by these new criminal laws just to protect the rights of India as a nation. The first is a terrorist act, which penalizes those kind of the acts which strike the terror, which create the terror using explosives, destructive materials, or those acts which threaten the unity, integrity, sovereignty, security, or the economic security of India. Very stringent kind of punishment is given from 3 years imprisonment to death penalty for this kind of the offense. Second offense is act of endangering sovereignty, unity, integrity of India, which criminalizes those acts which excite the feelings of separatism, which endanger the sovereignty, unity, or integrity of India. Punishment is 7 years to life imprisonment. In the third offense, right of the nation, as per the fake news are concerned, which is very recently goes on, which damages the sovereignty, unity, integrity, and security of India. So the fake news are concerned, the provisions are only penalizes the false information or the misleading information. Punishment is 3 years to the fine or with both. As far as the protection of the women and children from exploitation are concerned, Bharatiya Nyaya Sanhita consolidate the offenses against the women and the children into a single chapter. Previously, it is a scattered form of provisions are there, but now they make in a single chapter provisions are there, and they give more importance to all kind of the other offenses. They give more importance to this kind of the offenses against the women and children compared to other offenses. As far as the protection from marital rape is concerned, it extends the threshold age of minor girl below the age of 18 years rather than 15 years. They increasing the threshold from previously granting protection only to girls under the age of 15 years. Again, the new offense has been introduced to prevent the exploitation of the children from being coerced, harassed, manipulated, compel the children to go for to conduct, do unlawful activities. For this, the punishments are 3 years, goes up to 10 years with fine. Section 16 is very important one about the as far as the Bharatiya Nyaya Sanhita are concerned, because the section 69 protect the sexual autonomy of the women. Under this new law, the consent, if it is obtained by any person using or employing deceitful means, maybe suppressing one's own identity, making a false promise of employment, giving a promotion or a marriage, it is invalid, it's an offense. Engaging in such a sexual intercourse, though even not a rape, but its punishment is up to 10-year imprisonment with fine. As far as the safety of citizens are concerned, organized crime is specifically defined in Bharatiya Nyaya Sanhita to address the growing instances of syndicates, crime syndicates, criminal gangs. If these gangs are continuously indulging in kidnapping, vehicle theft, robbery, extortion, land grabbing, contract killing, cyber crimes, trafficking of person, drugs, weapons, illicit goods, trafficking of prostitution, forgery, breach of trust, counterfeiting, hawala transaction, mass marketing fraud, schemes which defraud the persons, even the banks and the financial institutions, such kind of the organized crimes are they are punishable now. Punishment up to 3 years to death penalty. Fine is from 1 lakh to 10 lakh. The offense of petty organized crimes have been introduced, which involves theft, snatching, cheating, unauthorized selling of tickets, and public examination of question papers, unauthorized gamblings and betting as well. So it penalizes above any of the above activities if it is continuously by a group, member of persons or a gang, 1 year imprisonment to 7 year imprisonment and fine are the form of punishment. Offense of mob lynching has been introduced. Acts of causing death or grievous hurt to a victim, and that death or grievous hurt, if it is based on his race, even caste also, personal belief system also, or any other ground, if it is committed by a group of 5 or more person, it is now punishable offense. So such act, if it result death, punishment is death penalty. If such act result grievous hurt, punishment is up to 7 year imprisonment. Another subcategory also introduced to the grievous hurt. If that grievous hurt result in permanent disability, punishment goes up to 10 years imprisonment up to life imprisonment. Such kind of the stringent punishment is awarded under this mob lynchings are concerned. As far as the repeat offenders are concerned, harsher punishment has been introduced as a repeat offender of theft is concerned. Mandatory minimum is 1 year, extend up to 5 years, and fine. To prevent theft from becoming a gateway crime, first time offenders are punished only with community service. Another new category of theft has been introduced. Offense of a snatching is there. Means it includes sudden, quick, or forcible seizure of any movable property. Punishment is going up to 3 year imprisonment and fine, because the cases of a chain snatching, phone snatching are considerable. Monetary loss are there, data loss are there, and most of the times these are the lowest priority crimes by the police are concerned. So with the specific recognition of this offense, effective prosecution of snatching has been facilitated. Moreover, this overall new criminal laws are a very inclusive law. It avoids the discrimination. The terms like the lunatic, idiot, and mental retardation replaced with very more respectful and dignified words like a person's of a unsound mind, intellectual disability. Even the word transgender has been included within the definition of a gender, which is in naturally in line with the modern Indian society. Most notable and significant contribution of these new criminal laws are there, which completely replace the colonial words with Bharatiya words. It replaced the terminologies like a Parliament of the United Kingdom, London Gazette, Her Majesty, Privy Council, Her Majesty's Government, Court of Justice in England, Dominion. These words are there in the previous criminal laws. Now these are removed and introduced the new criminal laws and adopting the Sanskritized names. Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, Bharatiya Sakshya Adhiniyam. It marks an end to the legacy of the British era, and it shows to proclamation about the rebirth of the Indian ethos. If you see the overall highlights of the new criminal laws, these new criminal laws give a justice, not the punishment actually. They give added the community service is a one form, because reformation is the ultimate object of the criminal justice system. Fixed time frame. Effort will be made to deliver justice within 3 years. There is a freedom from the cycle of day after date, limitation on the adjournments. Timeline in 35 sections are fixed. Registration of the FIR within 3 days of filing complaint electronically. Community punishment in PT cases. About 35 sections which are related to the crime against women and children, among which 13 new provisions are added with amendments. Gang rape is 20 years imprisonment or life imprisonment. Gang rape of a minor, death penalty or life imprisonment. If new sections are added, new clauses are added, false promises, concealing the identity for sexual intercourse, sexual relation is now a crime, is an offense. For regarding the proclaim offenders, penalty for 10 years or more, life imprisonment or death penalty for the guilty. Even the provisions are made arrangement with the other countries to confiscate the assets of the proclaimed offenders. First time, trial in absentia has been introduced. Provision to try the absconders in court. Provisions to seize properties inside India and outside nations. Computerization from police investigation to even the courtroom. E-records, zero FIR, EFIR, charge sheet will be digital. The victims will be provided information within 90 days. Forensic made mandatory in cases of a penalty of 7 years or more. Recordings of a testimonies as a investigation process are compulsorily made. Promotion of forensics, compulsory in 7 years or more form of punishment. Promotion of scientific methods in investigation. Object is to increase the conviction rates. Uniform justice system throughout the country. Elimination of third category of judicial magistrate, metropolitan magistrate, and assistant session judges. Now there will be four types of judicial officers: second class judicial magistrate and the first class judicial magistrate. Mob lynching as a new commission of added offenses. It defined for the first time if the murder, serious injuries caused by the caste, place of birth in a mob lynching, then that provision for 7-year imprisonments are there. Victim oriented laws are there. Opportunity for the victim to be heard. Right to information about its investigation process. Right to compensation and damages. Institutionalized zero FIRs. Use of technology in evidence to enhance the credibility of the electronic evidence. So, electronic and digital evidence now equivalent to other forms of evidence now. Server logs, location related evidences, voicemails, etc. They are now considered as an evidence and it is specifically streamlined in the new criminal laws. As far as the speedy justice systems are concerned, summary trials are mandatorily for PT and less serious cases. New criminal laws provide a list of the PT offenses or PT crimes. For that, community form of service also one of the form of punishment. And magistrate is empowered to conduct a summary trial for those kind of sentences which are up to 3 years. And the decisions regarding the cases which are against the civil servants, it must be made within 120 days. A number of under trial prisoners are there. So provisions are also taken caring of the under trial prisoners. Number of times when the witness see witnesses are the eyes and the ears of justice. Number of times witnesses are intimidated, harassed. They will not they will not come into courtroom because of this harassment, because of the intimidation, threatening. So the state governments needs these new laws came into taking care about the witness protection and empower the state government. The every state government prepare a WPS means witness protection scheme to for the purpose of security of the witnesses. So this scheme notified by the state, it will provide for the expenses which are incurred by the witnesses to in the courtroom. So witness protection scheme is is also one of the important scheme. So such of the major changes which are brought by the new criminal laws, which will be becomes effective from the 1st July 2024. If you see the overall major changes, they mostly increase the audio video, mostly increase the audio video recording of the crime scenes are concerned. Naturally, it is in line with the Supreme Court of India judgments also. And overview of the changes are really a welcoming change. The changes are there because we now come up from the we are overcoming from the colonial era. So for that purpose, Ministry of the Home Affairs launched one mobile app. So I request to everyone to download NCRB mobile app, NCRB Sankalan of Criminal Laws. That NCRB has launched a mobile app. That app name is a NCRB Sankalan of Criminal Laws. This app is a compilation of the new criminal laws, namely Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. This app is also available in Google Play Store as well as the Apple App Store also. It's very useful for the general public, students, court officers, advocates who want to enhance their knowledge about the new criminal laws, because this app is a comprehensive guide which provides complete information about the new criminal laws at one place. These new criminal laws as an index, it form up an index which linking all chapters also, sections of the new laws also. Even they provide the corresponding chart about the between the old and the new laws also. So you can download this NCRB Sankalan of Criminal Laws, go through it. It's a very user friendly design also. Even you can use this app offline mode as well. It's a very innovative feature, and try to update about the changes which are introduced in the new criminal laws. Thank you.